Good evening. Good evening, everybody. For those of you who don't know me yet, my name is Mac Barrett. I work at Roosevelt House as the curator of public programming. And so it is my distinct privilege and pleasure to welcome you all here tonight for what promises to be an extraordinary program. And I do so on behalf of Jonathan Fanter, director of Roosevelt House, Harold Holzer, as well as Hunter College president Jennifer Rabb. So this evening's program happens to feature two distinguished alums of the New York Times editorial board. Dorothy Samuels, who was a member of the Times editorial board for a record-setting 30 years, writing on a range of legal and social policy issues with a focus on the justice system, civil rights, and civil liberties. She continues work in those areas as a senior fellow at the Brennan Center for Justice, and we are proud to say she's also a member of the Roosevelt House Advisory Board. She will be speaking with Adam Cohen, who we are happy to welcome back to Roosevelt House. He is a former senior writer for Time magazine and author of Nothing to Fear, FDR's Inner Circle, and the 100 Days That Created Modern America. He is a graduate of Harvard Law School and was president of Volume 100 of the Harvard Law Review. Tonight we will hear about his new book, Supreme Inequality, which has the devastating subtitle of The Supreme Court's 50-Year Battle for a More Unjust America. The book came out just last week. You may have noticed it on the cover of the New York Times Book Review. The plan for the program is as follows. Adam will give a brief presentation on some of the themes of the book, and that will be followed by a conversation with Dorothy. And after that, as always, some questions from you guys from the audience. And we will all reconvene upstairs for a book signing and reception. Please do silence, shut off your cellular devices. And with that, I ask you to please join me in welcoming Adam Cohen.
Thank you so much. I have to begin with, obviously, an apology. I have been talking about this book for 10 straight days, literally almost without stop, and I've been doing very well until I spoke at Politics and Prose, the bookstore in D.C., and everything was fine. It was actually the party afterwards that went on till very, very late, at which I began to lose my voice, I think because it was very loud and hard to be heard. But I'm going to try my hardest to be clear, and I hope that you'll be able to understand me. So some of you may have seen this picture or this video. It went viral on Twitter about 3 weeks ago, and it's from a segment on CBS Morning News. They went to a shopping mall in New York State, north of the city, and they did a little experiment. The reporter had 5 plates that he put out. The top plate represented the top 20% of the country by wealth. The next was the next 20% by wealth, the middle 20%, second to last, and then finally the lowest 20% by wealth. And he asked people in the mall how he should distribute a pie with 10 slices to accurately reflect the wealth distribution in the country. And people were kind of apologetic that they had to point out that probably more of the slices should go on the top plate, and maybe as many as 4 slices should go on the top plate. And that's sort of what people were saying about 4 of the 10 on the top, and then they were distributing them on the other plates. That was not the correct answer, though. The correct answer is 9 of the top of the slices would go on that first plate, or 90 out of 100. And as he explained to them, once you put the 9 on that top 20%, you would take the next slice and give 8/10 of that last slice to the second 20%, the remaining 20% of that last slice to the middle, You would put crumbs on the fourth, and he did literally put crumbs. And then the last one you would give a bill to because they're in debt. Now, there are two really interesting things about this segment that, as I say, went viral. I think it really captured people's imagination because it showed so well, illustrated in such a simple way, how dire our wealth inequality has become. But two things that were particularly interesting are, one, that that people did not understand how the wealth is distributed, and secondly, well, I'm sorry. The first is how big the distribution, how off the distribution was. The second thing that was fascinating is the degree to which no one understood just how wide the disparities were. And there wasn't anyone who said, put 9 of the 10 slices on the top plate. So the reason that's important is we all know that we have large and rising wealth and income inequality reaching record levels, the highest since the 1920s before the great market crash. But people don't really understand just how great the disparities are. Now, when we talk about the disparities, people try to offer explanations. Why do we have such inequality in the country, and why has it been growing? The ones you hear a lot are people say that there are these large forces at work, like globalization and automation. And when they talk about government policy, they tend to talk about policies that were enacted by the president and by Congress. So people might talk about the George W. Bush tax cuts or the Reagan tax cuts. The reason I wrote this book was to try to add another element to the discussion and to talk about the role of the Supreme Court. It's almost never discussed in discussions of income inequality. People think that those larger forces in the political branches are making the important decisions, and the Supreme Court is just deciding cases according to the law. But in fact, when you look at the aggregate of the court's decisions over the last 50 years, they have been a major force for inequality. And why is that? Well, it starts with a man that I'm sure is familiar to us all. My book does speak about a 50-year time frame, and why is that? That's because when Nixon was elected in 1968, of course, there was a different court, the Warren Court, and the Warren Court had been a liberal bastion when Earl Warren came into office as Chief Justice. Within a year, the court handed down Brown v. Board of Education 9-0, ordering that schools be desegregated, and for the remainder of the Warren Court, they spent many years desegregating schools, public accommodations, and other things. And that was one of the things that got people angry at them, but of course they were doing other things. They were standing up for the rights of criminal defendants. In Gideon V. Wainwright, saying there's a right to appointed counsel if you can't afford one. In Miranda, saying that someone who's arrested has a right to a warning that they have the right to remain silent. So Nixon ran against all of this, and he promised that if he was elected, he would end the Warren Court by appointing different justices with a different view. So he was able to do that right away because, as it happened, Earl Warren was in the process of resigning, and President Johnson had an opportunity to fill the seat, but he nominated his friend Abe Fortas, who was already a justice on the court. The Senate did not confirm Fortas. Johnson, who was, known as the master of the Senate when he was majority leader and was supposed to know how to count noses and count votes in the Senate better than anyone, completely bungled this. He ends up leaving office without replacing Warren. And when Nixon comes in, he gets his first appointment to the Chief Justice, and he appoints Warren Burger, who he liked because Burger shared his view that the Warren Court had to be stopped. So that was the first appointment. And Abe Fortas remained on the court, but he had been weakened politically by the confirmation process, and Nixon saw that as an opportunity because Nixon was looking not only at the vacancy he had, the Chief Justiceship, which was vacant, but he was looking at which justices he could get off the court because he needed some to go for him to get a conservative majority. Nixon knew that Fortas had been politically weakened, and he knew that there was a bit of a scandal. Fortas was accepting consulting payments from a foundation, the Wolfson Foundation, which was run by a financier who was in some legal trouble and eventually ended up in prison. Nixon saw that as an opportunity to really threaten and blackmail Fortas into resigning. And it's a big thing in the book. I talk about this a lot because I think it's been, criminally underappreciated by historians, is that Fortas did not behave perfectly by any means, but a lot of people, a lot of judges were doing this sort of thing. There were other justices who were accepting money from foundations. Fortas did not do anything that warranted his removal. And what was striking, though, was the tactics Nixon used of sending his Attorney General, John Mitchell, to the Supreme Court to meet with Earl Warren before he stepped down, and basically to threaten Fortas if he did not give up his seat, the Nixon Justice Department would prosecute not only Fortas, but quite possibly his wife, who had been involved in another criminal investigation. She was also a law partner at the same firm Fortas had been at, but she had been cleared. But Nixon was able to really blackmail Fortas into stepping down, and it worked. Fortas did step down, which created vacancy number 2 for Nixon. Nixon ends up getting 4 appointments in 3 years, one of the fastest turnovers on the court. And when he's done with his 4th appointment, he put Harry Blackmun in Fortas' seat, Lewis Powell, and William Rehnquist in the next 2 vacancies. Of course, some of us may remember Harry Blackmun as a liberal, which he was at the end of his tenure, and he wrote Roe v. Wade, and he was one of the most liberal members of the court at the end. He was not a liberal at the beginning. He was known as one of the 2 Minnesota twins because he and Berger had been childhood friends in Minnesota. He voted with Berger, and for quite a while, in some very important cases, he provided the critical 5th vote for a conservative majority. So over the years, the 50 years, justices have come and justices have gone, but even though we have some new faces, we never changed the division that, or the head count that Nixon created. We've always had a conservative Chief Justice. It was Berger, then Rehnquist, then Roberts, and they've always had a conservative majority behind them. So that's why 50 years, because that has been the court we've been living with for 50 years. If you think about it, in that time, 50 years, we've had conservative Congresses and liberal ones, right? Democrats have held the House and Senate at various times. Republicans have. We've had conservative presidents and liberal ones. We have only had a conservative Supreme Court that entire 50 years. So why is it a driver of inequality? How do we show that that's true? So there's something called the World Inequality Report, which is put out by a group of economists, including Thomas Piketty. It looks at inequality in nations around the world, and in its discussion of the United States, it says that the drivers of inequality in America have been educational inequality and unprogressive taxation. Those are the 2 main drivers. Well, there is a tremendous amount of educational inequality in the United States. This was a few years ago, the Washington Post did a story about inequality in Pennsylvania. How much money school districts had to spend on regular operations. The wealthiest or highest spending district in the state spent more than 3 times as much as the lowest spending one, which is in the coal country of Pennsylvania. And you can imagine all of the quality teachers, textbooks, lab equipment, other things that extra money provides for the wealthier schools. And it's not, of course, just Pennsylvania. There's vast inequalities across the United States. So why do we blame this on the Supreme Court? Well, in 1973, there was a critically important decision, Rodriguez v. San Antonio School Board. And the issue was, does the Equal Protection Clause require states to distribute money equally between rich and poor school districts? And it's hard to get in this mindset now, but in the early 1970s, pretty much everyone thought it did. So law professors and other academics were writing articles and books saying, equal protection says when the government acts, it has to treat all of its people equally. So if it's going to run a public school system, it has to run equal public schools. There were a lot of federal and state courts that were finding just that, and a tremendous amount of momentum was building. Rodriguez was about a case in Texas where a group of Mexican-American parents and school children sued because their school district was very much underfunded, and even though it taxed at a higher rate than the wealthy districts, it just didn't have the tax base to raise enough money to have good schools. They won in the district court unanimously. It was a 3-judge district court. Comes up to the Supreme Court. Supreme Court rules 5-4 against them. no obligation to fund equally. And of course, as you can figure out, if Fortas had remained on the court, if Nixon had not driven him off, through really criminal tactics, it would have come out 5-4 the other way, because Fortas was the most liberal member of the Warren Court. And then a year later, there was another important case, Milliken v. Bradley. There, the NAACP was trying to do something about the very segregated schools in Detroit, which were getting more segregated every year with white flight. And they realized that it wouldn't make any sense to sue Detroit's school system to integrate the schools, because at this point there just weren't enough whites in Detroit. The only way to give the black children in Detroit an integrated education was to come up with what they called a metropolitan area remedy. So a remedy that moved children around the entire metropolitan area. Judge Roth, the district court judge in the case, who was moderately conservative and wasn't so excited about this at the beginning, agreed with him and said the only way to get integrated schools was to do a metropolitan area remedy. And he came up with really a very clever and practical solution, which was to cut the Detroit metropolitan area into pie wedges, essentially, which would include part of the city and then part of the suburbs. So every school district in the area would be 70% white and 30% black. So there was no fear of just sending a few kids from the suburbs, on a bus into a school in the inner city. It wasn't that type of a plan. It was a plan that would ensure that every district would be well integrated. It was upheld by the Intermediate Federal Court of Appeals, and then 5-4, the Supreme Court reverses, again, because Harry Blackmun took Fortas's place. Now, if that's why we can blame the Supreme Court for educational inequality, and I believe we can, how can we attribute blame to them for the other thing the World Inequality Report pointed to, which is the vast problem of non-progressive taxation? Taxes on the wealthy have been going down quite a bit during the last 50 years. It's not what the voters want. This is just one poll, but anytime you poll the public, people want higher taxes on the wealthy. They say it again and again. In this case, it's registered voters. Why don't we have it then? Well, I don't know if you remember, but when the Trump tax bill was being voted on in late 2017, there were sort of new levels at which campaign contributors just said outright to the media, to elected officials, if you don't cut taxes for the wealthy, we're going to stop contributing. And here's a case where Lindsey Graham said, our financial contributions will stop. And he says in the body of the article that a lot of incumbents will not be reelected unless they cut taxes on the rich. So even though voters strongly wanted higher taxes on the rich, a majority of Congress listened to their contributors, not to the voters. So why is this the fault of the Supreme Court? Because starting in 1976 in Buckley versus Vallejo, the Supreme Court has said money equals speech. It's protected by the First Amendment. And in this case, they struck down a key part of the campaign finance law that Congress passed after Watergate. And it was a good law that regulated both contributions and expenditures. The court said because money is speech, the expenditure limit had to fall. And since then, there have been many, many more decisions, as you all know, striking down other parts of campaign finance regulation, going down to Citizens United, where they made the really incredible holding that corporations have a right to spend unlimited amounts of their own treasury to elect candidates. So I guess it's the campaign finance cases that we can say have created the influence that the wealthy have on issues like tax policy. And if the writers of the World Inequality Report were to ask me, why do we have such non-progressive taxes in the country, I would absolutely say it's because of the Buckley line of cases. It's because of the influence that contributors have in setting tax policy. So that's the Supreme Court. And then, in the book, I go through many other areas where the court has been a force for inequality. In union law, where they've been very anti-union, in employment discrimination law, where they've gone out of their way, often very creatively, to rule against people who have absolutely been discriminated against illegally in the workplace. in corporate law, where they took up the tort reform movement that the business community had in the 70s and 80s that wasn't doing very well in the legislature. The Supreme Court has given them a lot of what they sought by putting in strict limits on class actions and punitive damages. And then the criminal law area, the Supreme Court has been a major driver of mass incarceration, which is itself a driver of inequality. So just to end, and Dorothy and I will start talking in a minute, I think what's really important to realize is when we look at the last 50 years, it could have been very different, right? It could have been that Nixon didn't succeed in creating this court that he did. It could have been that Fortas remained in his seat. It could have been that there were many other ways in which the Republicans have just done a better job of getting and holding the court. And, I say in the book that the conservative majority we've had for the last 50 years is sort of bookended by the theft of Fortas' seat and then the theft of Merrick Garland's seat. Because if Merrick Garland had been allowed to have a hearing and been confirmed, that would have created the first liberal Supreme Court in many decades. But of course, Mitch McConnell did not allow that to happen. So it could have been very different. And in the book, I actually quote this Ed Sparer, who was a poverty lawyer who became an academic, and he said after one decision, Dandridge v. Williams, which I haven't spoken of yet, but it's the decision that really ended the welfare rights movement and really did more to turn the court's back on the poor than any other. He said after that, very sadly, that if the court had decided Dandridge differently, it could have been a different America. And I think it's just important to remember on all these issues, if we had a slightly different court, we could have had a different America. So, Dorothy, why don't we begin a conversation?
Everybody. Adam, this is a little bit like Old Home Week.
It is.
It was mentioned at the beginning that Adam and I, for a period, were colleagues at the New York Times editorial board. And when we went from the beautiful old building on West 43rd Street to the new building, the less said, the better, we actually had offices across the hall, in fact, with glass doors so you could see across, and spent many an afternoon talking about the cases, even as they were coming down, even as we were figuring out what to say. And so I feel like we're going to continue that conversation now. And I must say, in the several years since that period of our professional life ended, and I don't think it's the reason, but things have not improved on the Supreme Court in terms of having a court that actually puts the core values, constitutional values of equality and liberty and fairness in the fore. But I don't think it's because we left the Times. So congratulations on the new book.
Thank you.
The last book you wrote was Buck v. Bell, and that was the famous case about the sterilization of a young woman who's wrongly thought to be, quote, feeble-minded. And in this book, it's a much broader picture, and it takes you into the modern political situation and legal situation. How did you come upon the topic? What made you want to focus on this?
Yes, well, as you say, the last book I wrote, Imbeciles, was about the Buck versus Bell case, and it was that I chose because I just wanted to try to understand the court by looking at one of the worst decisions they've ever made, which it was, and one that wasn't very well known. But in that case, the Supreme Court 8-1 not only allowed the state of Virginia to sterilize this poor woman, young woman. There was nothing wrong with her. She just had a very hard life and had been taken in by a foster family and then actually raped by the nephew of the woman she was working for. And when she got pregnant, they decided to just get rid of her by going and getting her declared feeble-minded, which was not hard to do. She's sent to a colony for epileptics and feeble-minded. And when she gets there, they've just adopted this law to sterilize the feeble-minded, and they decide to make her the test case. So her story was very sad, and the court not only upheld her sterilization. But Oliver Wendell Holmes wrote this horrific decision in which he said, really, the eugenics movement is right and important, and we need to sterilize more of these people so we're not, swamped by tides of imbecility. So that was a horrible decision, and I was very interested in sort of explicating that and showing why the court was wrong. But while I was working on it, of course, also occurred to me, the modern court is not much better. And the particular theme of imbeciles was that the court was siding with the strong, the state of Virginia and the medical establishment against the weak, poor Carrie Buck, who had no one standing up for her. And it occurred to me that that's true of our modern court as well. On almost every issue, they have been standing up for the powerful against the weak. And in the way that's shaken out in our modern society, that has led to strong economic inequality. So I decided that that was a story worth telling. And then particularly after the 2016 election, I just thought, I guess correctly, that things would get worse. And I thought, when my book came out, this is the sort of stuff people would be talking about, and it would be a good moment to shine this light on the court. So that's how I got to it.
Well, I think, a big part of the spotlight goes in the book to the Warren Court. And in a lot of ways, the book is a salute to the Warren Court and an appreciation of what it did in some of the opinions for the poor, and to advance the highest principles in the Constitution and in our sort of in the Bill of Rights pantheon. But the courts, and that's certainly how I grew up thinking about the Supreme Court. You're so much younger. I don't know about you, but it hasn't always been that way, even before this court. I mean, one of the things you say in the court, the Warren Court, which I think formed the image of the role of the Supreme Court in our society, in our system of government, it was really an anomaly.
It was an outlier. If you look at the history of the court, during the, before the Civil War, they were on the side of the slaveholders, right? We all learned the Dred Scott case where, they actually had the opportunity to hear the case of an enslaved man who said that he had a right to be free, and they said that as a black man, he had no right to even be heard in federal court. After the Civil War, after, the North has won, there's a challenge to segregated railroad cars in Louisiana, Plessy versus Ferguson. The court sides with segregation. In the 20s, they did not only what they did in the Buck versus Bell case of embracing eugenics, but there was a progressive movement that was passing laws to protect workers, child labor laws. The court struck down many of these. And as I wrote about in my book about FDR, Nothing to Fear, when he comes into office and the nation is collapsed, 25% unemployment, it's not clear how to save the system, he comes up with some major legislation, the National Industrial Recovery Act, the Agricultural Adjustment Act. The Supreme Court strikes them down. It's only when he threatens to pack the court that begins to change. So you're right, when you look at I could go on in the 1940s, Korematsu, where they upheld Japanese internment. The Warren Court was this one brief, bright period, and it didn't last very long.
You talk a little bit in the book as you review some of the decisions at different phases of the court. You talk a little bit about the backgrounds of the justices, and you seem to say that it really matters what the justice's background is and whether or not they've had experience with poverty or some hardship in their life, something, as Obama said, that gives you empathy.
Yes, I do believe that's generally, although not always true, because every time you say this, then someone says, well, Clarence Thomas grew up in Pinpoint, Georgia, very poor, and yes. So there's always an exception that proves a rule. But during the height of the Warren Court, when you look at them, and it's just impossible to overstate the degree to which they did a 180-degree turn on poor people. For most of the Supreme Court's history, they said terrible things about poor people. They regarded the poor as, a horrible, criminal, diseased, nefarious group. And suddenly in the Warren era, you see this compassion and this understanding that, as they actually say in one case, that we understand that the poor are poor because of forces largely beyond their control. So the court that's doing that, yes, includes people like Fortas, who grew up poor, Arthur Goldberg, who grew up poor, Hugo Black, who grew up poor in Alabama, and others. And there were actually 5 justices on the Warren Court who all grew up in or near poverty. And although I don't think it's a one-to-one correlation, I do think in the case of Sonia Sotomayor, who we know grew up, right here in New York in the Soundview projects in the Bronx with a single mother and, having to inject herself because she had juvenile diabetes. I think that generally there is a certain level of empathy. And I would say when we look at the majority of this court, the fact that they have had such privileged lives, including, in the case of almost all of them, Harvard or Yale law school educations. I think it matters. And that the Dandridge case, which I alluded to, where the court, I think, very cruelly closed the door on the possibility of ruling for people on welfare, it was written by Potter Stewart, who Potter Stewart had the most blue chip resume you could possibly imagine of growing up in wealth and privilege in Ohio and skull and bones at Yale and Yale Law School and Oxford and big law firms and all that. And the way in which he wrote about this poor welfare family that was really being driven deep, deep into poverty by a new Maryland law that put a cap on the amount of welfare that large families got. Potter Stewart, I think, was writing from his experience, which was one in which he didn't know any poor people.
You're reminding me about one of the things I really love about this book, which is you not only get sort of the legal theories and the facts of the major cases, but you also get that, how that really affects people's lives. And I think knowing you and working with you all those years, I really feel this book is such a reflection of that concern that is, has driven so much of your writing through the years. Remind us for a moment, though, some of the great decisions of the Warren Court. Brown v. Board, obviously one of them. Let's just briefly mention some of the others, because they had so many breakthroughs, things that we just take for granted today.
Sure, Gideon V. Wainwright was so huge, right? I mean, that was the case in which they ruled for the first time that a poor criminal defendant has a right to a lawyer, because really the system doesn't work if you have to go into court and you're ignorant of the law, you maybe are not well educated at all, and you have to suddenly defend yourself against a well-skilled prosecutor. So to say that there's a right to appointed counsel was major. We mentioned Miranda, but it's interesting when Warren retired, they asked him, what case he was most proud of. And people assumed that he would say Brown versus Board of Education, certainly his most famous case, and a lot of people think of it as the one that was most transformative. But he said Baker v. Carr in that line of cases. And those were the cases that looked at redistricting and looked at legislative districting and said that the very unequal districts that existed at that time in state legislatures, where you might have a rural county with 15,000 people in it, might get the same one legislator as the big city in a state, which had 10 or more times as many. That inequality was unconstitutional, and that went on. It was applied to state legislative districts and congressional districts. And he said it was so important because he really thought the most important thing about America was its democracy. And you don't have democracy without rulings like that.
It is a contrast so stark to the current court we have. We saw an elevation of democracy, of participation, and thinking that part of the role of the court was to step in to remedy deviations from democratic ability to participate. The poll tax, right, is tossed out. Obstacles to voting, and you could contrast that just even with recent decisions from the Roberts Court and the refusal to intervene in the politicized really gerrymandering that robbed people's votes, just washing the court's hands of it and whatever. But we get to the end of the Warren Court, and you talk about 2 or 3 decisions where in the language of the decisions, the justices who write them seem to be trying to take the law to making poor people, what we call in the law a protected class, who would be entitled to, whose cases and situations would be entitled to extra scrutiny, a much better justification by the government before they could do things that affected them negatively. And that changes immediately. But what would have happened? How might things have been differently if poor people had been declared a protected class, like racial minorities, and assuming that hadn't been undone right away? How might that have played out so the country would be different?
Right. So the Warren Court was doing really amazing things for poor people. It was the very first case I talk about in Chapter 1 is a case called King v. Smith, where a poor woman in Selma, Alabama, with 4 kids, a widow, is working in the cotton fields, picking cotton, and she's working in a diner as a cook, and she also is getting money from welfare because those 2 jobs pay so poorly, and just scraping by. And then one day they come and say to her, you know, we heard from your neighbors that you have a boyfriend, and because of that, we're taking your welfare away. And there was what was known as the man in the house rule. And she very bravely challenged that all the way up to the Supreme Court and paid a real price for that back home. But the Supreme Court, 9-0 in 1968, strikes down the man in the house rule, and that ends up affecting 400,000 children nationwide who would have been harmed by the man in the house rule. So that's amazing. But in that case, and in quite a few others where they rule for poor people, they did it on statutory grounds. They found some reason why the AFDC law, or in one case, the right to travel, they didn't go so far as to say that the poor were a suspect class. But in a number of cases, they kept hinting at it, including the poll tax case, which you mentioned. They struck down the poll tax, and they said there was language saying that lines drawn on the basis of race were offensive. Lines drawn on the basis of wealth were offensive, just in the way lines drawn on the basis of race were. So they were hinting in that case, Harper, the poll tax case, and others, that maybe we're going to declare the poor to be a suspect class. If they had done that, it would have been a very powerful tool for poverty lawyers to use, because the courts are very much more willing to strike down laws that put a burden on a group if they're a suspect class. So any law that is specifically harder on racial minorities or religious minorities is very likely to be struck down. If the poor were a suspect class, you could see many different challenges that, based on that, would make the lives of the poor better. And in fact, when I was in Washington losing my voice, I was on a panel with Peter Edelman, who is a great scholar of poverty law and also was a high official in the Clinton administration who resigned to protest Clinton signing the 1996 welfare reform law that ended welfare. And Professor Edelman has written about what we could have done with the poor as a suspect class. You know, one thing, just one example, the rate at which people get welfare and the level of benefits that they get varies so much from state to state. So if you're in New York or California and you're on welfare, you're not getting a lot. You know, they're not generous programs anywhere. But compared to someone who is in Arkansas or Wyoming, you're doing well. And you could imagine a lawsuit, for example, on behalf of poor people in Arkansas and Wyoming saying, you know, these are federal programs that are paid for by Congress, although there's a state contribution as well. Well, you can't have a federal program that allows this much disparity so that poor people in some states don't get, you know, almost anything. So that's one example, but there would have been many others. Now, to be honest, it would be a hard thing, you know, in some cases to draw lines, you know, because it's clear when a law burdens a racial group, usually much harder to say what kind of a law burdens poor people unconstitutionally, because almost every law does, right? So if you charge, $1 to get on the bus, that's harder for a poor person to pay than for a rich person. Does that mean that charging to get on the bus at all is unconstitutional? Probably not. But so it would have been a process for the court to try to decide how to apply the stricter scrutiny that they would apply for the case of the poor if they were a suspect class. But I think it would have had many concrete benefits for the poor, including, as I say, for poor people in the most disadvantaged states in the country.
Now, you spent a period of time before going into journalism actually as a lawyer for the Southern Poverty Law Center and for the ACLU, and you were in the South and litigating different cases, including school cases. Talk about how you felt the decisions of the court or the direction of the court as you were actually on the ground trying to improve education.
Yeah, so, despite the very slight differences in our ages, I also grew up with the Warren Court very much in mind, and the Warren Court and its rulings were a major reason I went to law school, because that's what I thought the law could do, the sort of things they were doing. But yes, by the time I graduated from law school, it was no longer the Warren Court. I still did go into public interest law, as you say, but a lot of it was really trying to work around the great damage that the post-Warren Court had done. So I did work on a major school case in Alabama for years that tried to equalize funding between rich and poor school districts. Well, the only reason we needed to bring that lawsuit was because Rodriguez had been lost. If it had been won, Alabama and every other country would have equalized its funding. So we were working in the shadow of the Berger Court and of Rodriguez, and in that case we won at the trial court, but we ended up losing in the Alabama Supreme Court, which was also at that point quite right wing. I was also I was working in a part of the ACLU in the national office called the Race and Poverty Unit, and the degree to which it was extremely difficult to do much in poverty law because of the Dandridge case that I mentioned, where the court said that it was not going to strike down this family cap that Maryland put on the amount of benefits families got, even as they had more children. And the court not only upheld the family cap, but, as I said, used language that said we're essentially just washing our hands of the whole welfare area. So it was very difficult to bring poverty law cases in that environment because pretty much the federal courts had said, we don't care. And honestly, it is one reason I migrated towards journalism, because I think for the sort of things I was trying to do in the law, it became very difficult under the modern court.
Now, in fairness, talking about the Berger Court, which came right after Warren's departure, in fairness, we have to note that it did some very progressive things, and there were some areas where the Warren Court had a blind spot, women's rights, for example. And it wasn't until, now partly everything takes place, things are happening outside the courthouse doors. There are movements going on, and there are political wins and changes, and but the changes for women's rights and the big advances, Ruth Bader Ginsburg's campaign with the ACLU that was so successful, that occurs in the 80s. It occurs under Berger.
That's correct. And the Berger Court did have some high points, and actually, although it was the Berger Court that handed down that Dandridge decision that I've mentioned, 2 weeks before it, oddly enough, it gave poor people the biggest victory, perhaps in the entire history of the Supreme Court, in a case named Goldberg versus Kelly, where amazingly they said that any jurisdiction, before they cut someone off from welfare, has to give them a hearing, an actual hearing, an opportunity to be heard, before they lose benefits, because benefits are so important and are the subsistence that families rely on. And that was incredibly important because, as you might imagine,
But that was heard in
Yeah.
in the Warren years and
Yeah.
then decided.
Yeah, but it was decided by the Berger court, and Berger dissented very angrily
Yes,
because it
very
wasn't what he
dissented.
wanted. But that was such a step forward because before that, people were being thrown off the rolls all the time because the caseworker didn't like them, or they said something the caseworker didn't like, or they, were late to show up for a meeting or something. And the court really amazingly, focused on the important thing, which is, this is the money that puts food on the table for, millions of children around the country. We're not saying it can never be taken away, but you have to at least give an opportunity to be heard. And in that decision, they also talked about, poor people being subject to forces beyond their control. It's just impossible to imagine today's court handing down anything
So
like
if you
Goldberg.
were in today's court, and we haven't gotten into great detail about some of the outstanding decisions of the Roberts Court, including, today, the big news today is that the court announced that Obamacare is coming back to the Supreme Court on an issue in an area I thought was settled, which is the constitutionality of the coverage mandate, right? But that's coming back, I guess, with some other twist. But there's a case where Roberts, on the front pages, got lots of credit for upholding the law and seeming to act beyond or above or to the side, or a calculated decision about the politics of it and the standing of the court. But as you write, I believe correctly in your book, he really stole with the other hand and really dealt a very harsh blow to poor people with the other hand.
Yeah, that's right. When I was first thinking about writing this book, I was having dinner with a friend of mine who's one of the leading experts on the Affordable Care Act, particularly in New York State. And I said, I think that really the thesis holds up, but the one area, I wonder about is they did uphold the Affordable Care Act. And she said, that is the best example for your book because they upheld the main part of the Affordable Care Act, but they struck down Medicaid expansion, which was, provided Medicaid for millions of the very poorest Americans. And they did it on such a flimsy constitutional basis, a reading of the spending clause that had never been applied by the court before, that it had the look of Roberts, first of all, probably trying to save face a little bit with his conservative allies, and he knew that they would be very angry at him for upholding Obamacare, so throwing them a bone. And then also, there's just, I think, a kind of nastiness to the poorest of the poor. And this was a way of saying, well, we're going to take your medical care away. I wonder if we should...
Yeah, we should open to questions. Yeah. We're going to run out of time. We should raise your hand. We should just wait for a microphone. And just please be brief and make it a real question.
I was very impressed with your work. I was very impressed with your work on Carrie Buck. But in my readings from various sources, what struck me the most was that Nazis gave credit to the American eugenics program, and that was their rationale for imposing it in Nazi Germany and throughout Europe. Can you speak to that in your research? Did you come across that as well?
Absolutely. And, it's a great question. The ties between American eugenicists and the Nazis were the most shocking thing that I found when I was doing the reporting. The degree to which the villain of my book, a guy named Harry Laughlin, who ran the eugenics record office, was in constant correspondence with Nazis, advising them about the racist laws that they were adopting and how to do it. He accepted an honorary degree from the University of Heidelberg in 1938 after it had purged all the Jews from its faculty, a time when most people were really understood that we had to cut all ties with Nazi Germany. So there were a lot of those ties, but one, to me, I'd say the single most devastating thing I learned in researching the book is a lot of the book talks about the 1924 immigration law, which was passed specifically for eugenic reasons. This Harry Laughlin was actually the eugenics advisor to Congress on the bill, and I saw his letterhead, which had eugenics advisor on it, to Congress. And he advised them that basically Eastern Europe and Italy were worse genetically, and that those immigrants would be more of a threat to our gene pool if they came in. And they put up enormous quotas, and it was really right before the Holocaust, right? So that law was a major reason that many Jews couldn't come to America fleeing the Holocaust. And, some years ago, there was an article in the New York Times in which someone discovered that Otto Frank had written many letters to our State Department trying to get visas for himself and his wife and his two daughters, Margot and Anne, and kept being turned down because of the 1924 immigration law. And as I say, because of a law that was passed for eugenic reasons. So what I realized after all this is when we say that Anne Frank died in a concentration camp in Germany because the Nazis thought the Jews were genetically inferior, that's true, but she also died there because the American Congress thought the Jews were genetically inferior. And that's really a sobering thought.
Let's take a question from someone else. There we go.
Would we get a more representative court?
Just wait for the microphone for a sec.
Would we get a more representative court if we disbanded the nuclear option and went back to 60, or limited age limit on judges?
I'm honestly not sure how I feel about the nuclear option, but the age limit, I think, would be a good idea, right? In the early part of the Republic, when the founders were writing the Constitution, the average justice served for under 60 years, right? Because that's how long people lived, right? So, under the age of 60. Thank you, I stand corrected. But they were not, very few were remaining on the court over the age of 60 because people just didn't live that long. They weren't envisioning, what we have now where, Clarence Thomas could be on the court for, 40 years or something. So I think that's an area where we should correct a part of the Constitution that was created in a very different time. And age limits would at least, yes, it would.
Very hard to do.
Very hard to do. That's the problem with all of these, proposed changes, that if it requires changing the Constitution, it's very hard to get a constitutional amendment. Now, we could change the number of justices just by a law, right? Because the number of justices on the court is not set in the Constitution and has been changed. It began as 6. So that might be more doable, but that, I think, has other problems, because I think once you begin politicizing the court in that way and say whoever has a majority in the elected branches can expand the number of seats and put more of their people on, I think you kind of lose what the court was meant to be. So, it's not an exciting answer, but when I look at all the reforms, I do think there's no substitute for winning presidential elections, winning Senate elections, and appointing the right people.
The other thing that helps is if folks know when to step down. And you have just an astonishing statistic in your book. I found it astonishing that, quote, all 6 of the most conservative justices who left the court since the mid-1960s were replaced by Republican presidents, while of the 6 most liberal justices, only 1 was replaced by a Democratic president. That's hanging on too long and gaming and bad luck.
Yes, Republicans just play the game much better. And look at Anthony Kennedy stepping down. He was in apparently perfectly good health. He stepped down at the last moment. He knew that a Republican president, Trump, would replace him and have a Republican Senate. He didn't know what would happen in the 2018 election. So he knew that he would get a conservative replacement. In the Obama administration, when Justice Ginsburg and Justice Breyer could have stepped down, they didn't. And I'm not saying they should have. I'm not saying that they necessarily did the wrong thing. But it's just also true that Republicans play the game to win, and Democrats sort of don't.
Well, you make a very convincing argument, but up until very recently, conservatives still carry on saying that the Supreme Court is the arm of Communism USA. Now, even though this has nothing to do with economic equality, do they hinge that craziness on marriage, on the gay marriage decision? What else might possibly drive that ridiculous position that they have?
Abortion, absolutely, yes. Yes, absolutely. Abortion and gay. Yeah, abortion, gay rights, but I think a lot, I always say never underestimate the role of race, right? I mean, for so many people, it was racial integration, simple racial integration, then the racial integration that occurred of the workplace, in which even the Berger court was fairly aggressive. The Milligan case that I mentioned, the court came within one case, within one vote, as I said, of a metropolitan area remedy. Well, that would have been busing between cities and suburbs. Well, the degree of opposition to that in white suburbs is so extreme. So I think it's all of these things, and that's
One of
Yeah.
the sad things that's recurring, and what's a theme of the Roberts Court right now and this term, is the unraveling of one of the Warren Court's great accomplishments, which was really honoring church-state separation. That's in the Constitution for a reason, in protecting democracy and protecting minorities and minority religions. And it's tied up now in the court with the gay rights issue is always in the background. But that's one of the areas of Warren Court progress that we're really seeing an unraveling going on right now, where we will see more steps this term, probably.
Very true. One more thing I want to say about this Republican anger, though, that a piece of it has always been, that they've accused the Warren Court and judicial liberals of judicial activism. They always say that. They say, you're a judicial activist, we believe in restraint. And, famously at Chief Justice Roberts' confirmation hearing, he said, a judge should be an umpire, right? So that's what they say. But when they actually have the power, the degree to which the conservatives on this court have been activists for their own goals, they have no compunction. And I'll just mention one example. They struck down, they tore out the heart of the Voting Rights Act in a case called Shelby County v. Holder, the pre-clearance requirement. Now, this is a law that was the crowning achievement of the civil rights movement. Many martyrs died for the right to vote and for this law. It was adopted by bipartisan majority in Congress and had to be reauthorized every number of years. So bipartisan majorities in Congress kept reauthorizing it. Reauthorizations were signed into law by Republican presidents, including George W. Bush and Ronald Reagan. So this is about as all-American a law as you can imagine. The court not only struck it down, but its basis for doing so was a ridiculous made-up constitutional doctrine that Roberts called equal sovereignty of the states. And Judge Richard Posner, who was a Reagan appointee to the Seventh Circuit, a conservative, wrote in Slate magazine after that decision came down that he had never heard of the doctrine of equal sovereignty of the states because it doesn't exist. So the idea that they were attacking liberals all those years for being judicially activists, they couldn't wait to be judicially activists for their causes.
Yes.
Isn't it true now that it's not only enough to control the presidency, but you must also control the Senate? Because of what McConnell did in the Garland situation. Now, he did that in the last year of Obama's term, but he could do it in the first year of any Democratic president's term. So we're stuck in a situation where literally the only way around this is to control both the presidency and the Senate.
I think that's a great point, and it's absolutely true because, we don't need to say that McConnell was being unprincipled. He said it himself because he said that if Trump were to make an appointment in the last year of his presidency, the Senate would hold hearings. So there's no, we don't need to call him a creep because he said he's a creep. So I agree with you. If we get a Democratic president, how do we know that McConnell would confirm any judges, right? Because they're not principled. They don't really care about constitutional norms. So, I mean, I agree with you. We need to win both.
One more. Oh.
Is there relevance today in terms of what President Roosevelt recommended in the 30s? Are among the proposals he made for reorganizing the court valid or available today?
Are you referring to the expansion of the court?
In 1937.
Yeah, the expansion. You know, I don't fault Roosevelt for doing that at the time. I think, you know, desperate times require desperate measures. And if you think about what that court was doing in the early, mid-1930s, they were essentially making it impossible for Roosevelt to enact a New Deal. And we were desperate. And I think that his threat to expand the court, add extra seats, appoint liberals so that his New Deal could get started was, I would say, necessary under the times. You know, historians debate whether it worked. Some people say that the court was already going to start changing its mind, but whatever, after he made that threat, it did work. I worry about doing it now, though, because, as I say, I think if either the Democrats or the Republicans just start to say, we don't like this particular court, we're going to expand it, it would be, I think, an endless cycle of each side threatening to do that, and ultimately we wouldn't have a Supreme Court. So, I mean, do I like the current Supreme Court that we're living under now? Not at all. Do I think they're doing terrible things like overturning Medicaid expansion after Congress grants it to millions of poor people, like ripping out the heart of the Voting Rights Act? Yes, I think they're doing terrible things. Do I think we'd be better off without any Supreme Court because we've destroyed it by endless rounds of court packing? No. So I would say that when Roosevelt did it under those dire circumstances, it was probably warranted. I wouldn't encourage anyone to do it just yet today.
On that uplifting note, I'm sorry we can't take the other questions. Thank you, Adam, for coming
Thank you,
to Roosevelt
Dorothy. It's a
House.
pleasure.
We have a reception upstairs and a book signing. Get Adam's book. It's a terrific book, and there's some refreshments. Thanks, everyone, for coming.